So what happens if you pass away without a trust in California? A lot of people think that their family will just get their home or their savings, but the reality is the government steps in first. In this video, we're going to talk about what that process looks like, how much it can cost, and how long your loved ones are going to have to wait, but more importantly, how to avoid that process. My name is Michael Pevney. I am an estate planning lawyer, and I create estate plans for California families. You can ask an estate planning question in the comments. I'm often able to respond. Some ways, sometimes I'm actually able to respond by way of a video. So if you have no estate plan set up for you, your state, the state you live in, now I practice in California, but pretty much every state has something similar. They have an estate plan already set up for you, and you may not like it. It's essentially what's known as the probate process, and that's what happens, what you have to go through if you die without a trust in place, or you have a will in place instead of a trust. If you have no estate plan in place, it means that you die intestate, so without a last will and testament. So if you die like that, the court decides who gets what, when, and under what circumstances, and that means that your family has to go through the court-supervised probate process. Even if they all agree on what's supposed to happen, even if you've told people ahead of time what you want to happen, and when I say told, I mean like verbally, hey, by the way, you're going to get the house, that's really not going to fly in probate court. We need to make sure that documents are written and either witnessed or notarized at the time that you sign it. So here's a brief overview of how probate works in California. It's the court's way of transferring your property when there's no trust set up and even if there is a will set up. So here's what happens. A petition has to be filed in court by somebody. The closer the relative is to you, whether that's a spouse or a child, the better. You have to wait several months for an initial hearing. The court eventually appoints an executor or a personal representative. Everything that you own has to be inventoried, appraised, and actually published publicly. You actually got to publish in a newspaper, like black and white written newspaper, that so-and-so has passed away. Anybody that they owe money to, show up in court, present your debt, and we will hash through it all. So those debts have to be paid, and then eventually things are going to be distributed, maybe to the people that you want, maybe to the people that you don't want. Usually takes a year or two. Where I practice a relatively simple estate, if somebody owns a home, it's about 18 months or so. And probate costs money, and it is based on the value of what you own and not necessarily the equity of the property that you own. And when I'm talking about equity, what are we really talking about here? We're talking about real estate. So where I practice in Southern California, the average home is worth about somewhere in the range of about $900,000 to $1.1 million. We're going to focus in on that $1 million range. It is set by statute. So much like the tax code, your income, a tax rate is applied to it. The value of what has to go through probate, a rate is tied to it. To get $1 million home through probate costs $46,000. Where does that money go? Half of it goes to the lawyer that ushers it through the probate system and all of these court hearings, and then the other half, the executor or the personal representative is entitled to get it. So, but like I said, it is not the equity in the home, it is the value of the home. So there could be a huge $800,000 mortgage against it, but you're not paying the probate fees on $200,000, you're paying it on the full $1 million. So we want to avoid that, and there is a great way to avoid that, and that's by putting the home inside of a living trust or owning the home jointly with people. Ask me why that is not a good idea, and I've got plenty of other videos on why we do not want to put other people, especially children, on the deed to a home. When things have to go through the court probate process, we actually also lose a lot of control and a lot of privacy, because this is court, and court is open to the public. Anybody that's interested gets to see what you had and eventually who it's going to, eventual forms that are filed, and who is receiving all of this stuff, all of your legacy. Sometimes people think that that can be a risk, a threat, and can make people that are inheriting things, especially if they're not super responsible, especially if they are young, especially if they're getting a large amount of money, a target for, I will say, people with not the best intentions about how people use their money, investment schemes, that sort of thing. We want to keep things private, and unfortunately, when we pass away without an estate plan, that is not private. And the timeline, it's not controlled by you. It is controlled by the court and potentially attorneys. What that means is if somebody's 18, they're entitled to inherit your legacy. They get it without any sort of strings attached at all. They get it immediately. Also, many assets are frozen during the process, so people that own a business, very difficult to run a business while the probate system is going on. Who's going to handle payroll? Who's going to make business decisions? Many small businesses shrivel up and end because they cannot handle ongoing business actions at the time. Nobody can make deals, nobody can pay payroll, and so many small businesses lose any and all value when they have to go through the probate process. Another reason to avoid it. So family in Orange County, where I practice, oftentimes loses a couple years of time and about $50,000 in probate costs just because things have to go through probate, just because assets, especially real estate, were not placed inside of a living trust. So that is typically what I advise most of my clients to do. We create an estate plan centered around a living trust, a revocable living trust that transfers property immediately and without court approval into that trust. And the trust says where things go, whether that is divided up equally among children, whether you order the home to be sold and things divided up equally among, or unequally, because you get to choose. And it's not just for people with kids, especially, this is almost especially important for people without kids. Sometimes we want things to go to nieces and nephews. Sometimes we want things to go to very close friends. A trust also gives us a lot of control about the terms by which people inherit things. If somebody who has special needs is going to inherit things, we want to make sure that that money is not eventually going to harm them by them making bad decisions with that money, and that things are paid for on their behalf. Or people that are just too young to handle a large amount of money at a younger age. They say, you know, the brain develops, frontal lobe isn't fully developed until you're 25 years old or so. Hundreds of thousands of dollars or $1 million into the lap of an 18-year-old. Are they going to make bad decisions? Answer that question for yourself. Would I have? No. I don't think I would have made it through college, through law school, and been a practicing attorney today. So we want to avoid the court probate process when we pass away, and the most effective way to do that, especially for people that own real estate, is to set up a living trust. Now, a full estate plan are more documents than just that trust. We want to make sure we have other documents like a financial power of attorney, like an advance healthcare directive, making sure that people are able to handle our finances while we are alive, and we're not able to, and making sure that healthcare decisions are honored. Do we want to pull the plug or not, so to speak? So that is just a little overview of what happens to your property, your stuff, if you pass away without a full estate plan, and more specifically, a trust in place. It's got to go through probate. It is expensive, it is time consuming, and you don't necessarily control where things go. The state of California, if you're in California, and the state that you live, every state has their own intestate laws, meaning you die, you pass away intestate without any sort of plan in place. So please follow me if this has been any sort of valuable information for you. You can like this video and ask a question in the comments section. I'm often able to respond to those. So once again, Michael Pevney, estate planning lawyer. You can follow a link in my profile or in the description to this video. And if you live in California, you can set up a time to speak with me for free. I appreciate your time and I appreciate your attention. Thanks.